Hey guys, attorney Jerry Parisi here, and today I'm going to answer the question, can I represent myself in a debt collection lawsuit? So can you defend yourself in court in a debt collection lawsuit? The answer is yes. You can absolutely, as a consumer, represent yourself, defend yourself in court against a debt collection lawsuit of any kind. I guess another question is, should I represent myself? So you can absolutely do it, but should you do it? And that really depends. It depends on a bunch of factors, right? So I think the first factor you want to look at is how much you're actually being sued for. I mean, if you're being sued for like $1,000, $1,500, is it worth it to hire an attorney? Maybe, maybe not. Call around. Most of us offer free consultations. We'll tell you how much our rates are. And I don't want to say it here because my rates change sometimes. And it depends on a bunch of factors, you know, what county your lawsuit was filed in. So this information may become outdated. But a lot of us charge very reasonable rates. I mean, it may not make sense to you if you're being sued for $1,000, $1,200, $1,500. But if you're being sued for, $3,000, $4,000, $5,000 and up, you may want to think about it. You may want to do that calculation in your head. Talk to the attorney, see like what your options are, whether you should settle the case or the attorney thinks you should settle, whether you can fight it. Another thing you want to think about that an attorney can help you look through is what defenses you have and if you have any counterclaims or affirmative defenses. So an affirmative defense is something that's a complete defense to the lawsuit, and if any of those apply, like the statute of limitations, then you can get the lawsuit dismissed without a ton of work. A counterclaim is a claim that you're suing. Obviously, you're countersuing the other party, whoever's filed the lawsuit. And counterclaims usually are best applied to debt collectors, not original creditors. So like a debt buyer, somebody who buys your debt on the open market for pennies on the dollar usually, and then they'll try to sue you to get a judgment in their favor or get a settlement. So there's a lot of counterclaims that could apply to a debt collector. They're subject to the Fair Debt Collection Practices Act, the FDCPA. So an attorney can help you see if you've got any solid FDCPA claims. If the statute of limitations is run, that's one. If they sue you in the wrong venue, in the wrong county, that's another FDCPA claim. If they misrepresent the amount of the debt or the character of the debt, that's another one. Guys, I recently had a case where I had a couple of these apply. A debt collector sued a young man in small claims court for a small debt, and he called me up. He was adamant that the statute of limitations had run. And how did he know that? Because he was in prison like 6 years ago when the statute of limitations would have started. He was in prison, and he knows he didn't make any payments after he went to prison. And he went to prison, I think it was more than 6 years ago. So he knew that was a defense, right? So we used that. We made played that as an affirmative defense and as a counterclaim. And then doing some research, talking to the debt collector, they sent us some account statements to try to disprove our affirmative defense. And what did they do with the account statements? They actually had sued him for an amount that was greater than the amount that they were entitled to, because he did actually make some payments, or somebody, I think maybe his sister, made some payments on the card, maybe while he was in prison, that brought the balance down, that brought it within the statute of limitations, but they mischaracterized on purpose the amount of the debt to try to get about $500 more or some amount more. So that's something that they're really not allowed to do. So we filed a suit in federal court, and we actually got some money back. We got more money in his pocket than the original lawsuit was for. And I was really happy with that. The client was really happy. And that was an awesome result that probably wouldn't have happened if he didn't hire me. So he hired me for a very reasonable amount that I thought. We got the case dismissed, and we were able to sue the debt collector for violating the FDCPA. So the client came out on top, better than he would have been if he had just done it himself. Even if he would have gotten the case dismissed on the statute of limitations claim defense, he actually came out on top because he hired me, took a look at the lawsuit, and found some other stuff, did some digging. So guys, basically, if there's a small, minor amount of money involved, you can handle it on your own. You can negotiate a settlement. You can file an answer and then negotiate a settlement with the debt collector, with the credit card company, whoever, with whatever type of debt it is. Negotiate a settlement on your own. Come up with a payment plan that works for you, or a lump sum that works for you. Another great thing about representing yourself, though, is that if the case is in magistrate court, now I'm only talking about magistrate, small claims court, cases under $15,000, whatever happens there, if either party is dissatisfied with the outcome, you can appeal it to a higher court, state or superior court in your county. You got to pay the filing fees, but you get a brand new case. So if you go and represent yourself, right, for whatever reason, the judge doesn't side with you and you lose for the full amount, you can file an appeal. You'll have to pay, like I said, the court fees, the filing fees to appeal it up to state or magistrate court, but the case starts over brand new. So at that point, if you want, you can go hire a lawyer to do the appeal. You got to make sure it's within 30 days of the judgment, though, so don't wait to appeal it. If that 30 days runs, you're done. But then you can hire a lawyer, or then you can negotiate a settlement if you tried to fight it on the merits. But that's a really great trick that a lot of people don't know. You can represent yourself in small claims court, lose, and still file an appeal, get a whole new case, start over, try it again. So there's some other things involved. There's a lot of law, that you want to look up if you're going to do it yourself. I don't necessarily recommend that you do it yourself. Always give an attorney a call. Give a couple attorneys a call and see what the rates are. See if they think it's a case that they could win. How much you're going to come out on top if you settle it by hiring an attorney versus doing it yourself. Do your due diligence before you go and represent yourself. But if you do represent yourself, do as much research as you can. Educate yourself. Look at my blog posts. I got a bunch of resources on how to deal with debt collection lawsuits. But I always recommend, if you can afford it, if it makes sense financially, to hire an attorney, because we can find stuff like the FDCPA claims I just talked about that you may not have been able to find. So doesn't hurt to give us a call at least. If you have any questions, you can call me, 404-594-5130. And there are a bunch of other attorneys in town that handle these types of cases. So Google them, talk to a few of us, and see what your options are. Thanks, guys.